technology which made it possible to see through things. Put a human being through a machine and you can see through the skin and you can see what's happening underneath. You can see its bones, you can see this creature's, the mechanics of the way this creature is put together. And through her endeavors, along with her husband Pierre, I suppose, well, sports science has moved forward and medicine has moved forward. I also do work in transparency and looking through things. And I think that's what corporate governance is really all about. It's creating a transparent framework, a framework where we can see through what's happening, to understand how things are done, how they ought to be done, and creating a procedure in terms of which certain things can be achieved. When we were approached to give this talk, we were given a metaphor. On a soccer pitch, there's some rules, and those rules are applicable, and there's a person on the field, there's a whistle, there are two people standing off the field, they've got flags, and when a law is broken, a whistle goes, the game stops, and there's a consequence for a breach of a rule. Now, as I understand it, in soccer or football, there are three rules. You can't touch the ball. When the ball goes out, it's out. And then there's the offside rule, which I don't understand, but I'm sure Leon over there could help us with the offside rule. In corporate governance, there are 218 rules. Each of those rules have about 4 or 5 subsections. And that's just the Companies Act. Then there's this little DVD that comes with the Companies Act, and those are the regulations. So when we talk about rules of the boardroom, you've got to look at 218 rules, as well as their 5 sub-rules. Let's call that 1,000 rules. Then there are the regulations. Then there's the MOI of the company, which is the Memorandum of Incorporation. Those are the rules in terms of which the corporation itself is run. Then you've got King 3 if you're in South Africa, or any other code if you're in another jurisdiction. If you're in the United States, you've got Sarbanes-Oxley, which is a pernicious piece of legislation and very difficult to implement. It drives the cost of running a corporation up. So I could today talk to you about the Companies Act and about sections 61 through to section 79 and talk to you about board procedure, talk to you about the way conflicts of interest are disclosed in board meetings. I could take you through the minutiae of all those sections of the Companies Act which are applicable to directors fulfilling a function as a director. And I was going to do that, but I've decided not to. I'm going to take a different approach, and I'm going to talk to you about the common law of fiduciary duties. Now, fiduciary is someone who's given something to look after. And that something that they're given doesn't belong to them, but they're given control over that thing. And that places them in a unique position to use that thing, which doesn't belong to them, for their own ends. So in the olden days, where the law of fiduciary duties originates, in England, during the 1200s, during the Crusades, what would happen was each lord of their manor would have their own army. They'd gather their army and they'd go off to Jerusalem and go and raise havoc. What they'd then do is give their estate to their brother or to someone to look after in their absence. And what would happen is they'd come back and they'd say, I'd like my house back, and the brother would go, no, it's mine. You gave it to me. And I'd say, no, I gave it to you to look after. Or they'd arrive home and they'd see that all their sheep had got no wool. Where's my wool? Oh, well, I didn't know you were coming back. I took the wool and I sold it. Well, give me the money. You can see there that the law had to develop techniques to ensure that when something is given to someone, that person has certain duties in respect of that thing and in respect of the owner of that thing. So if you look at an ordinary company, a company owns a piece of property. The shareholders of that company are mom and pop, but they're not really any good at running a company, so they put someone in charge of the company and they call that person a director. Now that director is tasked with the management of that company to ensure that that company thrives. What that director could do is decide, well, what I'm going to do is use that property, that piece of thing that belongs to the company, and use it to achieve economic benefits for myself. And that's what the law of fiduciary duties speaks to, and that's what it speaks about. What is corporate governance then? In this context, corporate governance is a set of principles, it's an approach, it's a procedure that we use to balance the interests of a person in charge of property with the person that owns the property. What corporate governance does, put some rules and procedures in place to ensure that everything is transparent. These are the rules. This is the offside rule. When you do something with my property, this is the way you need to do it. When you kick a ball, this is the way you kick it. In hockey, you're not allowed to use your hands, or I don't know. There's certain rules that apply to sport, and in the law of, in the area of corporate governance, what it does is it imposes rules in the way that things happen within a company. Now you think to yourself, okay, well these sports administration companies, I'm not quite sure how they're set up, but I assume they'd be non-profit organizations. They would be there to administer the sporting code and to deal with issues relating to that sport. So you think to yourself, well, what is that property that this company has? It doesn't own anything. It's not a trading entity. It's not as if it has a factory. It doesn't produce widgets. What is the thing that this company is to look after? And this is where I'd like to introduce an interesting concept. What this thing has is a thing called a license to do business. What does that mean? What is this license to do business? What this company or this administration, the sports administrating company or organization needs to do is to look after the integrity of a particular sport. Because that integrity is that thing which gives that sport value. So now, in the last couple of years, we've seen a couple of failures in sports administration. Just look at what's happened with the cricket, that's widely publicized. And there was a debacle in the athletics, that was widely publicized. And the way that those issues were dealt with didn't do very well for those administrators licensed to do business. Their license to do business was impaired. And why is that important? Because that license to do business directly affects those sporting codes. Who wants to sponsor a sporting code that isn't properly administered? Why would someone want to pour money and sponsor and be associated with a sporting code, for instance, that isn't properly administered or properly looked after? So corporate governance in the area of sports administration is particularly important because the thing that you're trying to save is not necessarily something that can be ring-fenced. You can't put this thing, this license to do business, in a safe to look after it and protect it. This is something notional that really has to be cultivated and looked after at every step of the way. So what does corporate governance do? It's a set of rules in terms of which a corporation is governed. Now, in an ordinary corporation, what you have is you've got shareholders, you've got directors, you've got suppliers, you've got lenders, you've got borrowers, you've got all kinds of people that you have to look after. In sports administration, who do you have to look after? You have to look after the license to do business. By doing that, you act in the best interests of your key stakeholders. And who they are? Your sportsmen, your sponsors, your audience. That's the most important part of this whole thing. If we look at sport now, it's a means of entertainment. If people don't watch rugby, well, you can't sell the rights to rugby. You can't sell the rights to rugby. You don't get any income. You can't pay your players. And the sport's influence in the public diminishes, and you impair your license to do business. So, stakeholders in respect of a sports administration company would be your sponsors, lenders, donors, service providers, people that look after your stadiums, things like that. So those are the people that need to be cared for. We've done those. So now I'm looking at the common law and the fiduciary duties. Touched on that. To explain the concept of fiduciary duty more clearly, I've drawn some comparisons where this relationship is prevalent. So you've got children. You think of a company as a child and the parents looking after the children, that same relationship exists. And you would never try and profit off your children. That would be uncouth, it would be immoral. because your child is something precious. It's something that you have to look after. It's something that has no agency of its own. So you do everything you can to look after your child. Similarly, if you look at a real estate agent. A real estate agent is someone that acts on behalf of the seller, and the real estate agent's duty is to look after that seller's interest entirely, in theory. I couldn't say that. Well, the thing about fiduciary duties is the duties that are imposed upon a director or someone acting in a fiduciary capacity. Those duties are absolute. You can't say, oh, well, that kind of apply. They actually apply. And when they apply, they must be applied. You can't walk away from them. You can't contract out of a fiduciary duty. You can in certain circumstances, but more often than not, it's something that applies fully to the fiduciary, and there's no way that he alone can avoid those duties. It's always the case that the beneficiary should be looked after in every instance. Now, there are 4 main fiduciary duties at common law, and these duties are, to an extent, quite intuitive. There's a duty to act under available powers, to exercise that power that you do have for a proper purpose. There's a duty to act in an independent and unfettered manner. And then there's the final duty, which is quite important, which is a duty to avoid a conflict of interest, and I've illustrated that this morning already.